Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a busy docket for you. Let's get to it. First, I'm going to explain what happened at the motion to dismiss the hearing that was heard regarding Chad Daybell's motion. Next, the court says not so fast for the Crumbleys and their attorneys. This is why you don't push old ladies. There's been so much of this going on lately. We may just have to ban fire. That's right. And another Mom of the Year contestant, and then finally our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. Before we can open up the docket, we need to take care of some housekeeping matters. First, if you haven't done so already, hit the subscribe button. Hit that little bell so you receive notifications of when we go live or put up new content. And thank you for everyone for joining us last night on our live program. And always remember to leave us a comment. And if you can't watch us on YouTube, you can always listen to us anytime by simply downloading your favorite podcasting app and just type in Crime Talk, and there we are. One more thing. We had a caller last night on our Patreon show who called in with a problem. She had sent off some money for an item, didn't come. She ultimately did a background search through CrimeTalk search, and guess what? She found out that the person that she was buying these items from had 26 prior cases regarding basically the same thing of theft. And I felt bad for her, but guess what? That's why you do that before you buy something from somebody. That's why you pay for CrimeTalk search before you go on the date from that person from the dating app. So go to crimetalksearch.com, get your background subscription service where you can find out who you're going out with, who you're doing business with. See if they have any convictions against them. Have they been evicted, filed for bankruptcy? Are they divorced? Maybe going through a divorce? Do they have any judgments against them from civil cases? All the types of things you want to know. Go to crimetalksearch.com. All right, let's go ahead and open the docket today. First, there was another hearing in the Chad Daybell matter, and it was in regards to the motion to dismiss, basically for grand jury misconduct. Okay? Now, these motions have not been made accessible to the public because it does involve grand jury proceedings, and they're supposed to be in secret. So let's do a quick background. What is a grand jury? Well, normally most people can be charged via a complaint and information. That's where the district attorney goes to the judge and says, "Judge, here's an affidavit for probable cause. Please find it." Judge signs off on it, and then you can go to a preliminary hearing. Or you can be indicted by grand jury. If you're indicted in federal court, you have a constitutional right to a grand jury, but states, not so much. But they can be used for special cases. They can be used as an investigative body, and it is a grand jury in comparison to a petite jury, which is 12 or less. A grand jury is 12 or more. Usually a grand jury is 15 to 25 people who will hear evidence in a case, and they will decide if there's in fact probable cause. Well, when they seat a grand jury, the government seats a grand jury, there is the judge that presides over those proceedings at the initial appearance of all the jurors to make sure that they're fair and impartial and that they can actually hear the cases. And if they think there's something they can't be fair and impartial for, they're supposed to let everybody know, say, "Hey, I can't be on this one. I'm out." Okay? But once the grand jurors are seated, the judge says, "Fine, go forth." The judge is no longer there. It's basically run by the prosecutor. And so let's say, for example, in the federal system, the grand jury meets a couple of times a month. Well, you may have multiple prosecutors that literally get 10 minutes to present probable cause for their particular case. They submit the paperwork, the grand jurors sign it, boom, next case. Okay? In the case like Lori Vallow and Chad Daybell, obviously a little more time was spent on it. And those proceedings are recorded. The votes of the grand jurors are generally secretive, and when somebody gets indicted, they're entitled to the grand jury transcripts, but normally they are covered by a protective order, which means you can't disseminate the grand jury transcripts to anyone other than basically, well, the attorneys and the defense team. The client usually can't even get them or get a copy for themselves. They can read them, but they can't get a copy of them. Now, you can always challenge the grand jury proceedings. You can file motions saying, hey, I want a list of everybody, everything that took place. And then you have specific arguments. You can say, hey, the entire grand jury is completely void because it was conducted improperly. Or you can challenge specific grand jurors. How do you challenge specific grand jurors? Basically, it's because they say something in the grand jury which makes you question whether they are being fair and impartial. Now, it is the job of the prosecutor handling the case saying, okay, that's your question, but understand the defendant is given presumption of innocence. You can't consider all these other bad acts. It's kind of like court, but it's very much relaxed. You've heard the saying, you can indict a ham sandwich, because that's really what it means. The prosecutor says you're going to find probable cause, you've found probable cause. The paperwork's all filled out. Literally, the grand jurors simply raise their hand and say probable cause. And 99% of the time, it is a no-brainer just like that. Well, here we have to read between the lines a little bit based upon the arguments that were made at the hearing. Now, the defense in this case, Chad Daybell, through his attorney, filed apparently a 55-page brief outlining why there were irregularities in the grand jury proceedings, and therefore a motion to dismiss the entire case should be granted. Now, the prosecutor, although they've had this brief for several weeks, basically couldn't meet the deadline to have their brief submitted, and although they made an oral argument today, they asked for additional time, and the court granted additional time up to April 6th to file their brief because they wanted to be able to cite to specific instances in the transcript, which they cannot do in open court, which is today, because of limitations put on by the court's order regarding the grand jury secrecy. The defense has then until April 20th to file a reply brief. So we are already at the end of April before we'll probably get any decision on this. So the argument that was made by the defense, and we got most of this through the rebuttal argument by the defense because he really stood on his motion that he had filed, basically saying that there was fairness and impartiality. There was not fairness and impartiality in this proceedings. The gist of the defense argument was that there was no fairness and impartiality of the proceedings. And therefore, he's asking for the court to throw out the grand jury indictment. And apparently some specific instances of this unfairness or lack of impartiality was cited in his motion, which comes from the transcripts, which we don't have a copy of. Now, interesting enough, the argument by the prosecutor was somewhat interesting in my regard. Now, first, when Miss Blake makes her argument, she sounds like she's a first-year law student that feels like she has to cover every point of law. Like, the court's going to get your brief, cut to the chase. Let me give you the cut to the chase version of her argument. Judge, everything was fair, but if it wasn't fair and there may be a couple of instances of misconduct or impermissible prosecutorial misconduct, well, that's okay, because even if a couple of grand jurors should have been disqualified, we still had at least 12, and that's probably good enough under the rules. If there was prosecutorial misconduct, maybe by allowing in information that was in fact impermissible, it really doesn't matter because it was only a little bit of impermissible evidence, and therefore it's okay. Once again, no harm, no foul. The prosecutor also alluded to, based upon some of the cases that she was citing to, that there's an allegation that there was some sort of relationship between a juror and one of the parties involved, i.e. prosecutors, or a witness in the case that maybe was disclosed or was not, but maybe they shouldn't have been involved. The district attorney, Ms. Blake, spent a lot of time arguing on that point, which makes me think that, small town, everybody knows everybody. Maybe this just wasn't the right grand jury for this particular individual, which kind of goes back to my point that we've made on lots of other cases regarding juror misconduct is, listen, let's get it right the first time so that you don't have to do it again, okay? Now, also, there was an argument about incomplete records, basically the recording in the grand jury proceeding. These hearings are usually transcribed or tape recorded, and when somebody stops and enters the room, they let everybody know, so-and-so's entered the room, we still have a quorum, something to that effect, and that there are no unauthorized people in the quorum. Now, apparently, Mr. Pryor wants an explanation as to why the recording or proceedings were not properly recorded, or at least not turned over to him. The government's argument is, hey, we can basically do what we want. We don't have to tell you what we did. And if the proceedings were, stopped, we don't really need to explain that to you. Bottom line. So to recap, basically everything was run fine. But if there was a problem, it's no big deal because we had enough jurors. We can do what we want. And even if you think that the motion to dismiss should be granted, hey, guess what? It really doesn't prevent us from refiling. Yes, we understand that it's a death penalty case and that the defendant is basically entitled to super due process. But we didn't give him super due process, but it doesn't mean even if you dismissed, we could still refile. So don't waste your time, Judge, by granting the motion to dismiss because we'll just come back and do it again anyway. But I think the bigger point is everybody in this case knew this was going to be a big case. It was going to be watched, it was going to be scrutinized, and that everything was going to be litigated. Why do prosecutors try to cut corners? Just do it the right way. Give him the due process that he deserves. You may not like Chad Daybell, but guess what? He's still entitled to that due process. And at the end of the hearing, the court did grant that the names of the grand jurors be provided to the defense so that there can be individual challenges made to those grand jurors. Makes sense, fundamental fairness. The government wanted to let everybody know, hey, we're prohibited from turning this over pursuant to the rules relating to grand juries. It's not that we didn't want to, we just needed a court order to do so. It makes you also wonder why Mr. Pryor hadn't turned it over beforehand. But I can tell you, if there's an issue in a grand jury, even the release of the grand jury transcripts, usually the prosecutors file those motions to turn that information over early on in the proceedings. I just don't understand why the prosecution just doesn't seem to be able to get their act together. They had a year on this case before they even indicted. We are now a year past indictment. And they're still running around like they're chickens like a chicken with their heads cut off, still trying to get organized. Listen, you knew when this hearing was. You knew the defense filed their brief in a timely manner. In fact, a day earlier than the deadline, and you couldn't be prepared to have your brief ready for the court. It's called mission accomplishment. It's called evenings and weekends to get that done and not just say, oh, well, Judge, we'll get it to you when we've had time to do it. Blows my mind. But I think that's the world that we're in these days. I once had a judge who thanked me for filing a brief on time, and I was like, well, you set a deadline. Why wouldn't I have done the deadline? She said, well, you'd be surprised the excuses that people come up with. So hopefully that explains in quick layman's terms what the issues are in the defense motion to dismiss as it relates to the grand juror alleged misconduct. We'll wait and see what the court does, but it'll probably be at least another month until we get a ruling on that motion. Just like everything else, no one's ever prepared on this case, and everything gets delayed. All right, next on the docket, the Crumbleys. Well, the judge said not so fast. So the Crumbleys are obviously the parents of the Ethan Crumbley, the shooter up there in Michigan. Well, the judge announced yesterday that she will be appointing independent counsel for Jennifer and James Crumbley, the parents of the alleged Michigan shooter. The judge expressed great concern of a mistrial happening due to conflicts of interest that the couple could encounter if they shared attorneys from the same law firm. Jennifer and James Crumbley are both charged with multiple counts of involuntary manslaughter stemming from the November 30th, 2020-21 mass shooting at the Oxford High School in the Detroit suburb of Oxford Township. Now, during the brief hearing yesterday morning, Judge Cheryl Matthews told the Crumbleys she will appoint each of them an attorney to advise them, not necessarily to replace their current lawyers. The issue was first raised by prosecution attorneys who filed a motion arguing that if convicted, the Crumbleys would seek an appeal based upon a conflict of interest from the representation of either of the attorneys. Now, Matthews delayed a hearing on the motion and instead asked the Crumbleys to meet with court-appointed lawyers to advise them on the potential conflict of interest. Matthews told the couple she's attempting to protect their rights and avoid the possibility of a mistrial due to an alleged conflict. Now, the next court hearing is set for April 5th. Matthews also told the Crumbleys she will ask them for written waivers if they decide to keep their attorneys. Okay? Everybody's entitled to their own representation, particularly in a criminal case. It's a lot easier in civil matters to represent multiple defendants. But in a criminal case, there's always the potential at any point fingers will be pointed at each other, and you have to have independent counsel. Normally, attorneys from the same firm are treated as one attorney, and therefore, hence the reason for the conflict. But like all rights, they can be waived if they are knowingly and voluntarily given up, and the court wants to make sure that they've been advised properly. And if there's going to be a waiver, there'll be a colloquy, a conversation between the judge and the defendant stating that they understand the conflict and they're willing to go forward. Why is that significant? Because if they go to trial and they lose, they will probably claim their attorneys weren't looking out for their best interest. They liked the other defendant more because maybe he or she was paying the bill, or their family. You just never know. I would never allow it. If I was the judge, I would just say, you know what, you're getting yourself new attorneys. That's it. Next on the docket, don't push old ladies, okay? Simple rule. Please meet Lauren Pazienza. Common spelling, Pazienza. Well, she is 26 years old, and she was arraigned on manslaughter charges yesterday for the death of an 87-year-old grandmother by the name of Barbara Gustern. Now, prosecutors say that Pazienza approached Gustern at random, called her the B word, pushed her, and then fled. The attack happened on March 10th around 8:30 p.m. when Gustern was walking towards a cab outside of her apartment building. The elderly victim was helped back onto her feet by a cyclist. Pazienza is then said to have watched as the ambulance crew took the frail older woman away with blood pouring from her head. Gustern died from her injuries some 5 days later. Prosecutors allege Pazienza then spent the next 2 weeks on the run, trying to cover her tracks. She quit her job immediately, deleted all of her social media, deleted her wedding website, and hid her phone at her aunt's house on Long Island. Pazienza, who grew up in the affluent Long Island town of Port Jefferson, also fled her Astoria, Queens apartment that she shares with her fiance. Now, eventually, Pazienza turned herself in after crystal clear photos surfaced of her getting on the subway 20 minutes after the alleged attack. Well, the attack, but you know what I'm saying, alleged. She's being held in custody, and the bond was set at $500,000 cash or a $1 million surety. Gustern's grandson, AJ, expressed his relief that she faces trial for the killing with the potential prison sentence of up to 25 years. He also said, "I'd like to stress innocent until proven guilty. But if she did do this, then I would like answers." Now, Pazienza has hired Arthur Adalia, a high-powered defense attorney who has previously represented Rudy Giuliani, Harvey Weinstein, and Roger Ailes. Adalia spoke to reporters after the arraignment and insisted that even if his client had shoved the 87-year-old woman, a manslaughter charge was unwarranted. Now, the A-list attorney also said that the pushing someone who is on the sidewalk isn't the same thing as pushing someone off of a cliff or pushing someone in front of a moving train. I understand that. But if you push someone and they die from the injury inflicted from when you push them, well, guess what? You can be held responsible for that. It's just the way it is. Kind of a but-for causation. That but for that push, she wouldn't have hit her head, and but for that, she wouldn't have died. It's kind of a negligence standard, which we've talked about here before. But if that's what people want, that's what people will get, I guess. Clearly, don't go around pushing old ladies. She should have been trying to help the Miss Gustern with the cab. But for whatever reason, she thought that she could do that way. I have received unconfirmed reports that she is the pusher from Port Jefferson going back as far as grade school. Apparently, she's a pusher. All right. Next on the docket. Should we ban fire? Because apparently it is setting lots of people on fire lately and harming them. So first story, a New York State man was angry at his ex-girlfriend because she was putting his belongings on the street and posting on Facebook about it. He is now standing trial for dousing 27-year-old Elizabeth Bell with gasoline and setting her on fire. Now, Miss Bell was found deceased in her Buffalo home early in the morning of January 11th of 2018. Now, Frank Brett Jr., the 33-year-old ex-boyfriend, was found several blocks away by police officers who followed footprints in the snow from the home's back door. Nicholas Alternos, Belle's brother, testified that he saw her ex-boyfriend walk into the house that night and go upstairs toward Belle's room. He said he heard a loud noise and then heard Belle's daughter scream. Alternos said that that's when he saw Brett coming down the stairs, fully engulfed in fire. Now, Belle's 7-year-old daughter suffered burns on her feet as she was forced to run past her mother's burning body. Prosecutors say the couple broke up 2 weeks earlier and that Brett moved out of the home. Investigators say they found a gallon-sized plastic bottle with Brent's DNA on it on the floor of Belle's bedroom. It had contained gasoline. They also found 2 lighters between the first and second floor and the gasoline on Belle's mattress. Now, Brent's trial continues as Brent's attorney says that the prosecution have no proof that Brent was the one who started the fire. It could have just started all by itself. You never know how that fire can start. Spontaneous combustion, I guess. Well, our next fire. Miami-Dade police say that they have arrested Sadrach Honorat, 31, for setting a man on fire and leaving him to die. According to the arrest report, witnesses told police they saw Honorat and another man arguing shortly after 11 a.m. The dispute turned into a physical fight, according to the police reports. Then Honorat doused the victim with an unknown liquid and lit him on fire. Police say the incident was captured on surveillance video and shows Honorat fleeing the scene on foot. The victim was pronounced dead on scene. And the Miami-Dade investigators sent out a description of the suspect, and someone called in with a tip pointing them to the suspect who is still wearing the same clothes. Mr. Honorat's been charged with second-degree murder and is being held without bond. Ladies and gentlemen, do we need to ban fire? Because, fire kills people, not people. Fire does. And I bring that up, ladies and gentlemen, because we've all heard over the years you have to ban guns. Guns are dangerous. Some people say people kill people, not guns. The point is, sometimes you have to demonstrate absurdity with absurdity. It is the individual. It doesn't matter their instrumentality of death. It is the individual starting the fire or using the firearm. Remember that next time you think that somebody wants to ban your firearm, or next thing you know, they'll be banning fire. Some fire is good, I guess, but it can be used in such evil ways that therefore the evilness outweighs any good that can possibly come from it. Just something to think about. All right, next on the docket, another Mother of the Year contestant, and I kind of feel sorry for this young woman because clearly something's not right. So last Sunday, a Texas woman by the name of Yesenia Cardenas was walking down a street in Corpus Christi, reportedly trying to hand off her 12-day-old baby to several people. One of those people was a woman by the name of Claudia Canales, who said she was driving down the street when she turned her car around to ask the 25-year-old mother if she needed help. She said she looked totally lost and thought she should intervene. Now, Cardenas reportedly said yes, she did need help and gave Canales the baby. Canales said the mother told her she had smoked marijuana and was unsure when her baby last ate. She also told Canales that she had run away from a house and some lady. Cardenas then asked Canales to take her infant child, but Canales called the police instead. Medics were called into the scene due to Cardenas appearing to be under the influence of an unknown substance, and Cardenas was arrested and charged with abandoning or endangering a child. The police confirmed that the baby is now in Child Protective Services. Now, like I said, I feel sorry for obviously the child, and I also feel a little sorry for this young woman, but at least she was trying to give the baby to somebody responsible in a position that could take care of the child. Ladies and gentlemen, when you start having kids, you got to stop the party scene. It's done. It's over. Your life revolves around children. It's just the way it is. You can get your life back in the next, 18 years when they go off to college. Other than that, they own you. Just remember that. All right. Today's dumb criminal. A contractor working at the Navy SEAL Museum was arrested for allegedly trying to steal a ballistic vest that was worn by a member of the team who raided Osama bin Laden's hideout. Kendall Rust, he's 30, said that he was taking the vest because he wanted to take a picture of it. An official at the museum in Fort Pierce, Florida, said the vest was part of the uniform for SEAL Team 6, and it's estimated to be worth about $50,000. Now, Russ was arrested on felony larceny charge and booked into the county jail, where he's being held in lieu of a $10,000 bond. Just like you don't push old ladies, you don't steal from the SEAL Museum. Now, maybe in this particular case, Mr. Russ will argue, I was just going to take a picture. I didn't have the intent to permanently deprive, and therefore it was not a theft. We'll see how things turn out, but somehow I think he had the intent to permanently deprive. And $50,000, I mean, the vest isn't worth that much. I mean, it's government property, and everybody knows in the government that the gear that everybody's wearing, even the SEALs, went to the lowest bidder. Just remember that, ladies and gentlemen. All right, that's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk.